Hi, everyone, and welcome to our Immigration Lead for Survivor series. Today, we'll be talking about VAWA. I will be your presenter, Omar Guerrero. I'm the Immigration Manager here at WTLC. So, first, I'm gonna tell you about where you can find the regulations and statutes regarding VAWA. First is 8 USC Section 1154. You can also find it in 8 CFR Section 204.2, as well as the INA Section 204A1. So, how does a person qualify for a vow? Well, the alien spouse must have been abused by their spouse during the marriage. There are cases where the person causing harm isn't a spouse, it's a child or a parent. In that situation, individuals would still be able to apply for VAWA. They just wouldn't have the same requirements as a spouse, such as the abuse could have happened at any time, as opposed to when it's a spouse, it needs to happen during marriage. The self-petitioner was subject to a battery or extreme cruelty by the U.S. citizen or legal permanent resident spouse, child, or parent. The self-petitioner lived with the abuser at some point. Note that they don't have to currently be living with that individual, they just have to have lived together at some point. And then if the person causing harm is a spouse, then the petitioner must have married the abuser in good faith. And before we end today's session, we will touch upon what good faith means. The self-petitioner has good moral character. This basically means that they cannot have committed certain crimes or immigration offenses, and the abuser must be a U.S. citizen or legal permanent resident. However, if the abuser lost their U.S. citizenship or legal permanent resident status due to an incident of domestic violence, the abused spouse or child may still be able to self-petition within 2 years of the abuser's loss of status. So, we're all wondering what qualifies as cruelty, because we all know what a battery is. Battery is usually hitting, punching, slapping, kicking, or hurting the other individual in any way. Well, for cruelty, immigration takes the stance of engaging in a pattern of behavior that would not appear abusive is considered individually. So this could be such as emotionally abusing the survivor by insulting them at home or in public, controlling where they go, forcing to have sex with them, threatening to take their child away, threatening to turn them over to immigration. So it's a wider range of things. It's always up to the person doing the VAWA for the survivor to really dig through and be really knowledgeable of the types of abuse a survivor can go through, and then find corroborating evidence such as and also articles that support those arguments. So as for the living together, of course, we all know what that means. They live together at some point. With some exceptions, please know that the self-petitioner must be currently living in the United States. There are some exceptions, such as if the abusive spouse was an employee of the United States government or armed services, or if the abuse occurred in the United States and now they're living. Again, this is something a professional should always evaluate when considering all the facts. And lastly, what is good faith marriage? Well, it means that you married this person because you love them. You didn't marry this person because you wanted to circumvent the immigration laws. Immigration does not support immigration fraud, which is just marrying someone in order to gain status. And again, people are like, well, how do I prove that I married this person in good faith? Well, usually we should use love letters that you sent to each other during the dating phase, pictures, maybe at a wedding, pictures of the wedding, friends that knew about the relationship. So there's a wider range of evidence that we can also use in this stance that immigration will take into account. As always, if you're all interested in wanting to know more or want to talk to me one on one, you can always email me, call me at my mobile, or call me at my office. Thank you.